I apologise for the delay in sitting. The fault is entirely mine. My brothers are innocent. Well, innocent of that anyway. Yes, Ms. Patel.
My Lords, it was put to me before the short adjournment that there was a finding against Delta at paragraph 59 of the judgment of LSJ in the High Court. And I just wanted to pick that up and make 2 points in response.
Which paragraph?
Paragraph 59.
69.
59.
59.
On page 146.
Yes.
And the point is that it wasn't disputed by the respondent that fuel intended to be sold to the corporation only became duty-free when it was clear that the fuel had been sold on a duty-free basis. The first answer to that is that, in fact, the question of when fuel becomes duty-free is a question of law and not of fact. And so it's open to my Lords to properly construe Section 20 of the Ordinance and Section 69, together with Section 30 of the Customs Act, to arrive at the conclusion that fuel imported by Delta on behalf of the corporation is duty-free. In relation to, it's clear that Delta is the instrument of the corporation's importation. And I just want to pick up on the reference to sale in paragraph 59 of the High Court judgment, because it is important to note that the statutory provisions treat sale as an entirely separate question from importation. So Section 20 of the Ordinance and Section 69 of the Customs Act make no reference to sale.
But I wonder how realistic this is. I mean, if we go back to the letter of 23rd July 2012 on page 75, which sets up the modern arrangements, there is a clear assumption by both parties that you have requests to refund a duty on fuel sold duty-free. Now, that's not what the statute says, but it seems to have been the sort of concessionary arrangements that have been in place since 1992, that you don't actually look, as you should technically under the statute, at what the position is at the point of importation into territorial waters. You have a sort of sensible arrangement whereby the accounting is done once the goods are on land. And the way that's been operated in relation to Delta is, and the Electricity Corporation, is that they pay the duty and get back a refund. I mean, you know, that's not what the statute says, but it's the way the concessionary arrangement is operated. I mean, I don't think it's against it. It just means that one shouldn't be expecting it all to fit very neatly into the precise words of the statute. And it explains why your clients accepted as they did, that was how things worked.
In relation to that point, my Lord, I do need to make clear, I think, that my client doesn't accept, and I've got now those Court of Appeal references, my client doesn't accept. I accept that it wasn't challenged in the High Court and that there's no contrary evidence before you, but just for the record, my client doesn't accept the existence of this alleged established procedure.
Well, then how do you explain what's in the letter of July 2012, which clearly seems to assume that your client is getting refunded, not, you know, I mean, it may, as an accounting matter, just means that two accounting items can just cancel each other out, but that's the way it seems to have been operated.
Well,
the letter's not specific to the Electricity Corporation, is it?
No, and in fact, if one looks at the earlier letter, the 1992 letter, my Lord, the paragraph that we looked at in that letter, in fact, indicated that the directions in that letter were probably directed at goods which were dutiable.
Yes, they were,
and
this
didn't
is dealing with goods which are not dutiable.
Yes, but so by extension from that, the 1992 letter and the 2012 letter do not appear to contemplate goods such as the fuel that we're concerned with.
Well, don't they? I thought everyone accepted that this letter was dealing with this sort of fuel. That's why it's not. That's why it's duty free. I mean, I may be wrong, but that's what the assumption has been throughout. I mean, there's nothing wrong with that. It's perfectly normal in this sort of area to find that the sort of concessions get muddled up with the law, and it's very difficult to disentangle one from the other. But
Yeah.
The statement of facts and issues, paragraph 4, refers to this letter as setting out the procedure to be followed regarding importation of fuel, including duty-free fuel, into BVI.
Yes, I hope that's not consistent with my submission just made, namely that it's a letter in general terms, which is not expressed to be setting directions specifically in relation to goods of this nature.
well, what's the point of having it in the agreed statement of fact if it's not dealing with the subject under appeal?
But I think that your answer to that is that it does, but it's sort of exclusive to you.
It clearly does apply, at least it's been treated so far as applying to this case. I mean, whether that's right or wrong, I don't know, but we've got no evidence to the contrary.
Yes. There are two distinct elements to the 2012 letter. One is the reference in the first paragraph to a pre-existing procedure that's changing.
Yeah.
And the second is the conditions in the bullets that we looked at before lunch. The first paragraph, as I said before lunch, it suggests that there was such a procedure in place, but there is
what other oil are they selling duty free? I mean, do we have any evidence about anything else?
No. We don't, my lord, and we don't have any evidence of the actual prior document that sets out this alleged procedure.
No, because everyone took it as being settled. That's what often happens. People proceed on a certain basis and we're stuck with it.
So 2 points in relation to that. Can I just now give you the references to the Court of Appeal judgment where counsel for the appellant explained why there was no evidence in response? Paragraphs, page 209 to 210. He says at the top, actually it's the bottom of 2008, My lady, my lords, we were put at somewhat of a disadvantage in this matter in the sense that the respondent filed their affidavit essentially late the afternoon of the hearing. And it's understood he's referring here to Mr. Romney's statement. The hearing was on Thursday. They filed it at 4:30 and served it on us after 5, and the hearing took place the next morning. And in that affidavit was when they suggested this procedure, which we knew to be wrong, by the way. You must, in fact, first send the fuel, pay duty on the fuel, and then, in fact, you are reimbursed. We knew it to be wrong. The problem, of course, is having done it on the afternoon. The matter was the morning. We had no chance, in fact, to respond to the affidavit, and the court erroneously suggested we were accepting that. We knew it was wrong because it was never done. That procedure applied for people who got duty-free concessions, as I say, like hotels, boat owners and whatnot. It had nothing to do with the corporation, and we, in fact, never paid duty prior to fuel being sent to the corporation. So the court must bear that in mind. And then you see again over the page 210 between lines 19 and 22.
Was that supported by evidence, new evidence in the Court of Appeal?
It's not, I'm afraid, my lord.
So what's it stated?
I am in some difficulty there, but I think it's right that I draw it to your attention.
Well, you might also draw to our attention the reply of the attorney. He says that he hears his friend giving evidence. There was nothing that was before the court below as to whether or not duty has ever been paid. So according to the Attorney General, there wasn't any basis for the finding made contrary to your client.
And I repeat Mr. Neal's mistake. But the question for this court is a question of law, namely whether the goods were liable to forfeiture. And whatever the practice may have been, that requires construing Section 20 of the Ordinance and Section 69 and Section 30 of the Act. And if this procedure is to have any import in relation to whether or not, excuse my pun, import, the goods are dutiable, the procedure needs to be a condition which has force of law. Now, I think it's right to point out that there are, in fact, two lots of alleged conditions that are relied on by the Commissioner in relation to why the fuel may, in fact, have been dutiable. And the first lot is the conditions that are set out in bullet points in the letter of 2012, which relate to, for example, permission and attendance, and those were discrete grounds in the notice of seizure as to why the goods were forfeited. And as I submitted before the short adjournment, Delta's case is that those are Section 29 conditions, and so those conditions cannot make the fuel dutiable under Section 69 of the Act. Then there is, secondarily, this alleged procedure, and we say that wasn't, whether or not that existed, as a matter of fact, it wasn't a condition at all in practice, and that an established course of dealing between the parties isn't the same thing as a condition, such as would be caught by Section 69 of the Act. So, whether or not the parties had, in fact, operated on the basis of this procedure, it can't alter the correct legal analysis of the question for my lords, which is whether or not these goods were in fact liable to forfeiture. It may very well have been that that procedure wasn't in fact a lawful procedure that could have been operated consistently with Section 69 of the Customs Act. In Delta's submission, the sorts of conditions that are in fact envisaged by Section 69 of the Act are conditions that would sensibly circumscribe the entitlement there to partial or full relief. So, for example, they might stipulate the degree of relief in relation to particular goods, or they might stipulate, for example, the amount of goods that could be imported free of duty. But it simply makes no sense to refer to a procedure for making goods dutiable as a condition to statutory entitlement for goods to be duty-free. And so whatever the factual position may have been, that practice cannot, as a matter of law, constitute a condition for the purposes of Section 69.
Well, another way of putting that is you cannot impose a condition which effectively nullifies the provision.
My Lord, yes.
Ms. Patel, we know that this consignment did go to the Electricity Corporation. I'm afraid I'm not clear in my mind as to whether there's evidence that what the charmer had on board was, as it were, at all material times destined for the Electricity Corporation. Is there evidence about that?
There's no evidence, my Lord, that there was any change of destination in relation to the goods.
Okay, well then.
So I hope that's dispositive of that. There hasn't been any suggestion on either side that there was any other destination.
No.
At any time.
Okay.
And so the reason why, in relation to the question of law then, and just to come back to this question of importation versus sale, and whether it is possible to say that the fuel could only have become duty-free when it was sold, it is important to note that for the purposes of the legal question, Section 20 of the Ordinance and Section 69 of the Customs Act make no reference to sale. They make reference to importation. And importation is therefore an entirely separate question to the question of sale. And it may very well be the case, as we say it was here, that Delta was importing on behalf of or as the corporation's instrument, notwithstanding that title didn't pass in the goods until they were in the tank, and in fact payment may have not, the payment for the fuel may not have passed until subsequently.
Well, I think under the contract it's quite clear. Payments come a month later, don't they, Mr. Patel?
They do.
Yes.
And so And it's also important to remember that there can, of course, only be one party out of Delta and the corporation conducting the importation, because you can only have the goods imported once into a territory. And so if we look...
Well, I wonder, importer is actually a defined term on MS 339, and it includes any owner or other person for the time being having a right to possession of or being beneficially interested in any imported goods.
That's...
You could conceivably have a number of people who fell within that definition.
My Lord is right, but then above we see that import means in relation to goods the bringing or arrival of goods by any means into the territory from a place outside. So one would expect that that can only happen once in relation to one shipment. And similarly, the section that my Lord Hughes took us to this morning, section 3.2a on MS 342, refers to the goods coming within the limits of territorial waters. So in relation to both of those, what's envisaged is a single time for importation. And I make...
But does that necessarily exclude the possibility of more than one people being importers? I mean, just to look at the definition of the law of the
It does you mind very much how many importers there are, Mr. Patel, as long as you're one of them.
That's the short point, my Lord. I simply made the point with a view to trying to make sense of the existence of Tank 7 being bonded, because it seems a great peculiarity that that tank would be bonded, i.e. creating dispensation for the contents being entitled to sit there free of duty. If it were the case that although the fuel sitting in the tank were the property of the corporation, and although the importation had taken place at the point in time the fuel was discharged into the tank, there was separately and prior to that point in time somebody else who was liable for duty because they were the importer. It would beg the question why you needed the tank at all.
Yes.
Well, you need the tank at all because you've signed a contract saying you'll keep some in reserve for the electricity company.
But my Lord's right, but that could be a tank of any kind. It needn't be a bonded tank.
No, I agree.
My Lords, those were my submissions on the first issue. I think I've addressed the three questions that I sought to address at the outset. We say that Section 69 and Section 20 are clear, that Delta did import on behalf of the corporation, and that its entitlement to do so wasn't affected by the 2008 letter, whether by reference to what appeared there to be conditions or by reference to the existence of a prior procedure. The second issue is not pursued. And in relation to the third issue, I just have three short factual points because I think I've covered...
What's the third issue?
The third issue is was the Commissioner in any event disentitled from contending that tank number 7 and its contents were liable to forfeiture? And that's a distinct point from issue 2, which relates to estoppel on the basis of what was set out as grounds in the notice of seizure. And that point is not pursued. In relation to issue 3, the appellant's, the respondent's case was set out in the notice of objection. At MS 283. And Delta essentially puts forward 3 sets of reasons as to why the Commissioner should be disentitled from contending that the fuel and the tank were liable to forfeiture. Firstly, Delta says that the Commissioner was aware that the disputed fuel was to be delivered to the corporation and that the corporation enjoyed a duty-free concession. This ground, I think, has been covered by my submissions before lunch in relation to why it was that the fuel was intended for delivery to the corporation, duty-free. And the points relate to the approval of the bonded tank for that specific purpose, the Commissioner being the only person with keys to that tank, and the provisions of Clause 3.5 of the agreement. The second point that Delta puts forward is that the Commissioner, to the knowledge of and without objection, Delta, to the knowledge of but without objection by the Commissioner, adopted the same procedure for other deliveries of fuel to the corporation. And there are just two factual references to give you here. My Lords have seen reference in the documents to the Ocean Princess discharging fuel into tank number 7 a few days after the Charmer. That's in the Statement of Facts and Issues at 14, paragraph 14, on MS 300. But it's also, more importantly, and in more detail in the evidence of Mr. Sylvester, on page 8. Paragraph 21B refers to the three different discharge events by the Ocean Princess, and B is clearly stated to be a discharge into the same bonded tank number 7 on September the 17th at 8:24 p.m. We see at paragraph 22 that it's Mr. Sylvester's evidence that the Commissioner was notified of the time and place of the above discharge, but no officer from the defendant was present, and no queries were raised about the discharge process, although the method used for the discharge was quite similar to that of the Charmer.
That means, does it, that there was no objection raised, not only to the discharge into tank 7, which is 21B, but also to the 39,000 odd at 29C, which were presumably commercial stock for Delta.
It's unclear, my Lord.
They're not into tank 7 anyway.
No.
So where, yes.
But certainly, I think we can be confident that there was no objection in relation to tank number 7, because that's what this affidavit was directed at.
All right.
And then we see at paragraph 24, there is mention of a meeting the following day between Mr. Romney of the Commissioner and Mr. Lettsam, Senior Customs Officer. Mr. Romney, in response to a question from the defendant about difficulties with the Ocean Princess, indicated that he had no problems with the manner in which fuel was discharged from this vessel. Again, it's not specific to discharge into any particular tank, but it would appear to be a blanket statement that there were no issues. And it hasn't been said by the Commissioner that, in fact, there were any issues about the discharge by the Ocean Princess into tank number 7. Lastly, on this point, Mr. Lettsam, at paragraph 10 of his witness statement, which is on page 3, just for completeness, he makes the same point in relation to that discharge by the Ocean Princess, but he also says, middle of that paragraph, in fact, as far as I'm aware, there were approximately 5 discharges of imported fuel since the 2012 letter from the defendant, and only once did Customs attend to witness the discharge procedure, obviously notwithstanding that it is said to be a condition in that letter that somebody attend. The third point that's made in relation to this issue is that the Commissioner was aware of the respondent Delta's intention to deliver the disputed fuel to the corporation and made no objection to the delivery. We've seen already the conversation that took place on the 5th of September. There's one other factual reference to give you here, and that's in relation to what happened on the 10th of September, page 7 and paragraph 18 of Mr. Sylvester's affidavit. The point here is that the Commissioner's officer had left tank number 7 unlocked, having opened it to permit a discharge of fuel from the tank to the corporation, it being his practice not to close it thereafter so that it could be refilled again, obviously bearing in mind the minimum requirements under the agreement to keep it topped up. So the only reason why the tank was able to be filled on the 16th of September was because the Commissioner, which was the only entity that had the keys to the tank, had left it open specifically to permit it to be topped up. So we say that in those circumstances, even if it was the practice between the parties to operate this refund procedure, it was clearly also the practice of the parties to adopt a procedure whereby the Commissioner would effectively consent to discharge into tank number 7 by leaving tank number 7 open, and in those circumstances it would be quite unfair to allow the Commissioner to object to that discharge, no objection having been made prior to the discharge, and quite the contrary, permission implicitly having been given through leaving the tank open. That point is picked up in the judgment of the High Court. At paragraph 89, and it's not a point that LSJ was impressed by. But we say that it is a point that my Lords should have in mind when considering the somewhat convoluted factual complexion of this case, and what is said to be an established procedure on one hand against Delta. It's important for my Lords to also bear in mind what appears to be a clear practice that stands in Delta's favour. And on that basis, it wouldn't be fair for the Commissioner to, at this point, for him to be entitled to assert that the contents of the tank, and indeed the tank itself, were liable to forfeiture on those grounds, no objection having been raised in those circumstances. I won't make any submissions on the cross-appeal in light of my learned friend's indication. And in relation to costs, my learned leader indicated that we would be, if successful, seeking the costs of the High Court proceedings in light of what happened below, but we would be very content to make submissions in writing, if appropriate, in due course, unless I can assist further.
Thank you very much. Thank you. Now, Mr. Gasper.
My Lords, I think only a very few matters, if I may. My learned friend's submissions do depend on establishing that BVIEC was the importer and so able to establish that the goods are not liable to duty, whereas we say that the position is that Delta was the importer. I would respectfully submit that the definition to which your Lordships just referred in section 3 rather indicates that we're right about that, in that the definition of import means in relation to goods the bringing or arrival of goods by any means into the territory from a place outside the territory. I was interested to see that definition appears 2 above K9, which is the definition of the dog. struck me as being unusual to find in a statute, but there we are. But there are a number of
But
indications.
why would the Electricity Corporation not be beneficially interested in the oil at the time of importation if there was a contract for
There was a contract
this oil to be sold to it?
Well, the question is really, what time does the liability to the pay with the duty arise? And at that time, up until the entry into the tanker fuel, the owner of the oil.
Well, beneficially. I wonder.
And we say that our interpretation is very much borne out by the factual background to the case. The question of the system of refunds of payment, which you were briefly taken to by my learned friend, it's worth, I think, noting that the submissions which were made by Mr. Neal in the Court of Appeal were quite wrong, to the extent that the system was something which was, if you like, raised at the 11th hour before the judge and had not been clearly part of the Commissioner's case. We can see at page 125 of the record that the evidence which was put in an affidavit by the Assistant Commissioner at paragraph 6, well, I think paragraph 5 and 6 deal with the letter dated the 23rd of July 2012, and then in paragraph 6, refunds are given to the respondent after it sells fuel duty-free. Thus, the respondent is aware that the fuel is not automatically duty-free on importation. Fuel is duty-free when it can be verified that it was sold on a duty-free basis. And if you just go to 128, you'll see that that affidavit in that form was sworn on the 5th of December 2012, but that it was also sworn on the date which is crossed out in the affidavit there, 24th of October 2012. We can tell that because reference to that affidavit is made and the point disputed in the affidavit of Bevis Sylvester, that which you've seen today, in which he comments on Mr. Romney's affidavit. Mr. Bevis Sylvester's second affidavit is where are we? Excuse me for a moment. That was sworn on the 8th of November 2012, so we can tell that that the Commissioner had made his case, and indeed it had been considered in evidence by the by Delta some months, I think, before the hearing in the High Court.
Have we got the date of the hearing?
Oh, we got the date of the judgment.
I know. I'm talking about the date of the hearing.
I think if I look at the SFI, it may not have been very long before the date of the judgment, but I.
There are dates in our chronology.
The date about that?
Sorry, but well, in any event, whether it was a short time before or a long time before, it was enough time before for Delta to put in evidence about it, because they did. It's referred to in Bevis Sylvester's affidavit. So the reference by counsel for Delta before the Court of Appeal at page 209, that they'd only received it in the morning of the afternoon, so to speak, is simply not right.
It doesn't help. I mean,
Well,
it's quite often one finds one's opponent putting in something late, and if it prejudices you, then you apply for time to put in your response to it.
Well, I would respectfully agree with that, but
Or you can't.
plainly there was not even any need to do that in the present case.
As you say, it wasn't an issue. And so
But not only that, but the judge's findings of fact about it were paragraph 57, I think, and paragraph 70.
Why did the Attorney General say There is nothing that was before the court below as to whether or not duty has ever been paid.
Well, I think that is possibly explicable on the basis that it was an accounting exercise, a paper exercise, rather than a cash exercise. I think it is correct that under the procedure which was operated, and I don't think this goes to who was liable, the exercise was carried out on an accounting basis, and once, of course, evidence was satisfactorily given that the fuel had been purchased by BVIEC and received by them for their use, then duty was not payable. But there does seem to have been, shall we say, a fairly frank exchange of views between counsel at that point of the transcript, where
Whether it was frank
one
or
was
whether it
accusing
was incomprehensible.
well, one was accusing the other of giving evidence, and sometimes one knows that provokes a reaction the other way. And well, I'm not sure that anything can really be
It doesn't
derived.
take us any further because there wasn't any further evidence put in, and we are stuck with the findings of the judge.
Yes, and the judge couldn't have been clearer at paragraphs 57 and 70 that was the position, and that was the agreed procedure. And indeed, if one then looks at the letter of July 2012, I think it's a point which has been made by your lordships in discussion with my learned friend. The whole point of the July 2012 letter, or not the whole point, but the first premise of the letter was that it would be helpful if the rather convoluted procedure of application for refund could be avoided, and that's at pages 97 to 98. And the letter begins eliminating the need for Delta Petroleum to submit requests for refund of duty on fuel sold duty-free, which obviously is on the premise that the liability for duty in the first instance is on Delta, and Delta can take advantage of the statutory entitlement that BVIEC had if they can be satisfied, or customs are satisfied, that it applies, and it only applies on the sole use of, and they satisfy that the fuel is indeed sold to BVIEC for the sole use of BVIEC. And I think on the second page of that letter, where my learned friend was referring to the third of the bullet points, and the sentence, in the case of duty-free entries, an authorised person from the eligible entity must stamp and certify the cargo is for the sole use of the entity. I think it was suggested that the person who was the eligible entity might be Delta, but I think that's plainly wrong. And what had to be done was confirmation by BVIEC that they had indeed purchased the fuel. And I would turn to the next point, which is the significance of the status of tank number 7. The respondents rely very much on the letter of, I think it's the first of the documents which is exhibited to one of the new affidavits. It's the first of Mr. Sylvester's exhibits. And that refers to, it's August 25th, 2008 letter. Please be advised that BVIEC's pipeline must be utilised at all times for the delivery of fuel to the BVIEC. However, as a means to facilitate legitimate trade, we will give permission to utilise tank number 7 under special requirements, etc., for additional storage and delivery only to the BVIEC. This is a privilege, and any contravention of the laws and guidelines of customs may result in the loss of such privilege. Well, that isn't, in our respectful submission, a letter which supports the proposition that it is indeed BVIEC who is the importer, rather the reverse. It's a matter of convenience for the assistance of trade. It would be wrong to think that the evidence about the exclusivity of tank number 7 was all one way, because it wasn't. I think I took you this morning to the evidence of the Commissioner himself at pages 112 to 113 of the record. It's paragraph 23. Paragraph 20, I'm sorry, of his affidavit, in which he says that fuel can move to and from tank number 7, a tank usually reserved to hold fuel for use by the British Virgin Islands Electricity Corporation, to other tanks. Thus, tank number 7 is said to be a bonded tank. But he goes on to say, additionally, fuel in tank number 7 can be diverted to other use. So the status of tank number 7 doesn't decide the question whether or not the goods are not dutiable. It is simply there in order to assist the arrangements for both Delta and BVIEC when the fuel is imported, as we say, by Delta. And indeed, that was a matter which was considered by the judge in the course of her judgment at paragraph 61. Where she describes the arguments effectively still put by the respondent. He says the applicant, that's the Commissioner, puts no store in the fact that the fuel was purportedly discharged into what has been described as a bonded tank. And she ends by saying the tank in question is simply used to deposit fuel intended for use by the BVIEC and is open and accessible to the respondent.
What is meant by the statement that in the first paragraph of the letter of the 25th of August 2008 that tank number 7 be added to the BVIEC storage tank farm? And was there a storage tank farm for the electricity company?
I think that well, I've understood it in this way. I'm not sure whether there's detailed explanation in the evidence, but I understand that Pockwood Pond is at the deltas. Actually, perhaps I shouldn't. I don't want to run into risk.
Well, it's a power station, isn't it?
Yes.
Well, Pockwood Pond is an area, I look at it.
Yeah.
And if you look at the agreement, the contract, it refers both to the buyer, that is to say the electricity people, having storage tanks in that vicinity, at Pockwood Pond, as it says. And it's fairly clear that Delta also had a depot there, because that's where it put the rest of its oil.
But I think it is also clear from that letter that the delivery to the tank and the delivery to BVIEC is not to be considered as simply the same thing, because BVIEC's pipeline must be utilized at all time for the delivery of fuel to the BVIEC. And you remember the distinction has been picked up in paragraphs in the affidavits which I took you to this morning, where there's a two-stage process. There's delivery to the tank from the boat and delivery from the tank to the BVIEC pipeline. And we know that what happened on this occasion was that...
But I've understood your submission just now to be that one shouldn't take from this letter that it was contemplated that tank number 7 was for the exclusive use of Delta Petroleum, for BVIEC, is that right?
Well, no, I don't think I would go so far as to say that. I was saying that it is not a conclusion you can draw from that letter that delivery to the BVIEC tank is necessarily equivalent to duty-free to the fuel being non-dutiable at the time that immediately before it is delivered to the tank.
Well,
And what is happening is that Delta is selling fuel to BVIEC, Delta are bringing the fuel in. We say that Delta is the importer and so liable for the duty. Because BVIEC do not have to pay the duty, then if and when it can be established that Delta have sold the fuel to the BVIEC, there is a statutory entitlement in BVIEC to have it duty-free. And consequently, at that point, once it's established, the Delta can obtain the refund.
Well, if that's the extent of the submission, I'm not sure that this letter provides any assistance at all.
Well, I was really referring to it to say that it doesn't decide the case or give very great assistance to my learned friend's argument.
Well, it all comes down to whether BVIEC was the importer or whether Delta was.
Well, exactly that.
I mean, this letter can be read consistent with either.
Well, exactly. Well, my learned friend wants you to read it one way. I'm prepared to say that you might be able to read it that way, but you could equally well not read it that way, and that the indications and the evidence, which was before the judge, perfectly entitled her to come to the conclusion that she did. And indeed, as appears to have been understood by everybody, that the first immediate liability for the payment of the duty was on Delta and not on BVIEC. Well, I'll leave the tanks, if I may, and go on to the manifests, which my learned friend relied on. There are manifests which appear, again, to have different implications. I took you this morning to the manifest at page 99, I think it is, of the record. And you'll recall that in relation to that, that has the importer, name of importer, Delta, diesel, 122,000, weight, BVIC, diesel, nil, bonded, diesel, nil, and that is identified by the deponent, the Commissioner himself, in paragraph 8 on page 92, as being the manifest that the Customs received on the 29th of August 2012. In other words, before all this blew up into a problem. This is when the charmer arrives. And we know that the row which took place, if you like, was engendered by the telephone call exchanges, etc., and the failure to notify Customs, at least effectively, so that they could be present when the fuel was offloaded on, I think, the 17th of September, 16th. And then my learned friend refers you to the other manifests, which I think are in the exhibit to the new Better Sylvester affidavit. Yes. Just give me one moment. Which begin, if you like, with the clearest indication, BS 17. And that is the document which you looked at. It's the second in the exhibit, which has the words on it. List is imported solely for the use of the BVI Electricity Corporation at Potwood Pond. As I understand, it is effectively after there have been these difficulties in offloading. So if one was going to look at which of the manifests was the reliable indication, perhaps one would look at the first. And I have only seen these exhibits today, I'm bound to say, or to be absolutely accurate, in the middle of last night. But
But are you questioning the accuracy of this?
No.
What did your witnesses say about these documents exhibited by Mr. Sylvester? I think you had time to comment on them.
I don't know because, as I say, I wasn't aware of the existence of this affidavit by Mr. Sylvester until very recently.
I think it
So I
must
assume
follow
it must
from
follow that they didn't.
There was no comment.
No, exactly. Yep, exactly. But in any case, I wonder whether it's really of any great significance to the status of either who was the importer and liable for the duty in the first instance, whether the manifests say one thing or say another thing. If they say inconsistent things, which they plainly do, does it take the matter any further? If we are right, then the importer was Delta. Under Section 69, the questions of what the words "on behalf of" mean, then plainly, at the stage that the at all times there is an intention on behalf of Delta to sell to the BVIC. But I ask the rhetorical question, does that make them the importer on behalf of BVIC, or make BVIC the importer of the goods themselves? And that's, I suppose, a question, but one can well imagine a situation where the owners of the motor vessel Charmer would be chartered by the BVIEC to bring the fuel which they had already purchased in wherever Delta brought it from originally, to bring it to BVIC on their behalf. But that is not what was happening. What was happening was the BVIC were bringing the fuel and selling it to BVIC, who were becoming the owner of it at the time that it was, so to speak, title passed to them. There's only one other matter that I really wanted to address by way of reply. My learned friend refers to a number of matters which it suggested disentitled my clients from relying on this point. We would respectfully submit that there is really nothing in those points. If the system was as it appears to have been, the fact that the customs didn't insist on their rights in relation to the July shipment could not alter it. But the evidence about that was, in fact, that the customs had protested and told them, in effect, not to do it again. And that's dealt with by the judge in paragraphs 93 and 94 of the judgment. You can see that she said there that Delta's counsel had submitted that there had been a similar process followed in the past. She takes into account that the Commissioner had accepted that there had been incidents in the past, but the Commissioner's evidence was, particularly in relation to the July agreement, I think we need to go back to the affidavit, but these were acknowledged breaches which were brought to the attention of the respondent. There was no inconsistency in the Department's approach. And she says and finds, in the light of the applicant's evidence and the limited example provided by the respondent, the court is not satisfied any genuine inconsistency is made out which would have stopped the applicant from pursuing these proceedings. So I would respectfully submit that there would be no principal basis, if you like, to second-guess that conclusion on her part. Lord, I'm grateful.
Thank you very much. Well, we're grateful to Council for their submissions in this surprisingly interesting case. The Board will take time to consider what advice they will humbly tender to Her Majesty.